The smile left Mason Keene's face the second the judge unfolded the letter. It was just after 9:40 on a gray Monday morning in Cook County, and the courtroom had that cold, overlit stillness that makes every page turn sound like a threat. Keene had spent the last 20 minutes leaning back in his chair, cufflinks flashing, acting like this was beneath him. Another tenant dispute, another old man behind on rent, another easy eviction dressed up as principal. Then Judge Helena Varga adjusted her glasses, looked over the top of that yellowing page, and asked one question. "Mr. Keene, is this your father's signature on Keene Residential letterhead?" Keene sat forward. His lawyer touched his sleeve. Too late. The veteran at the far end of the room didn't move. Earl Dixon, 71 years old, Army, 2 tours, a cane resting against the bench, jaw locked so tight it looked painful. He had already lost his apartment, his medication cooler, half his winter clothes, and the framed burial flag from his wife's funeral when the movers dumped his life onto South Halsted in sleet. He had been called a delinquent, a nuisance, and a holdover occupant in papers filed under oath. Now the whole room was staring at one old letter, and what happened next turned a simple eviction case into the public destruction of a landlord who thought paperwork could be bullied into silence, because this was never just about missed rent. It wasn't even really about Earl Dixon. It was about a redevelopment scheme, a stack of false filings, and one entitled man who believed poor tenants, elderly tenants, and especially a quiet veteran living alone were the easiest people in the city to erase. By the end of that hearing, the court wasn't asking whether Earl should have been removed from apartment 3R. It was asking how many people Mason Keene had lied to, how many records he had concealed, and whether the bank financing his luxury conversion had been fed fiction from the very start. If you appreciate stories where power finally meets consequences, stay with me, because once that letter was read into the record, Mason Keene's empire didn't crack. It started collapsing floor by floor. Earl Dixon had lived in that brick walk-up at 1847 South Halsted since 2003. Back then, the building still had warped radiators, chipped green trim, and an owner named Arthur Keene, Mason's father, who ran the place like a neighborhood business instead of a spreadsheet. Earl wasn't just another tenant. After coming home from military service and years of warehouse work, he had become the unofficial backbone of the property. He salted the front steps in winter, reset tripped breakers, chased off copper thieves twice, and during Arthur Keene's stroke recovery in 2004, basically kept the building functioning for 8 months. That was when the promise was made. Not casually, not verbally, not in some foggy handshake nobody could prove. Arthur Keene typed it on company letterhead dated June 17, 2004, had it signed, had it notarized, and gave Earl a copy. In exchange for the maintenance work he had performed during Arthur's incapacity, Earl and his wife Clara would have the right to occupy apartment 3R for the rest of their natural lives at a fixed monthly rent of $525. The letter stated in plain language that the agreement would bind heirs, assigns, purchasers, and agents of the property. That should have protected him. It didn't. Not when Arthur died, and not when Mason took over the portfolio in 2022 and rebranded the family company into Keene Sterling Properties with glossy brochures, drone footage, and a private equity vocabulary. Mason didn't see a building with tenants. He saw underperforming square footage 2 miles from downtown. He saw a brick frontage, transit access, and a future refinance package worth millions if every unit could be delivered vacant. Earl Dixon was a problem on a spreadsheet. At first, the pressure came quietly. New online payment rules, late fees on money orders that had always been accepted before, a compliance inspection every other week. Then came the renovation notices, even though no permits had been pulled. Then the accusation that Earl's granddaughter had become an unauthorized occupant because she stayed there for 6 days after a gallbladder surgery. Then the rent portal supposedly failed twice, and the company rejected his mailed payment after the deadline passed. 3 weeks later, Keene filed for possession, claiming chronic non-payment and refusal to cure. The language in the complaint was surgical. It made Earl sound reckless, evasive, disposable. The truth was uglier. On January 8, 2025, With the wind pushing dirty snow across Halstead and the temperature stuck at 19 degrees, the movers came before noon. Earl was at a VA clinic appointment when they changed the lock. By the time his granddaughter Tessa got there, his life was on the sidewalk under blue tarps, prescription bottles, army photos, a rusted tool bag, Clara's church hat box, the burial flag, all of it tagged and exposed like evidence from a crime nobody intended to investigate. That should have been the end of it. It wasn't. The first person who took the case seriously was a legal aid attorney named Maya Alvarez. She had seen bad landlords before. She had seen illegal lockouts, forged notices, fake repair claims. But something about this one bothered her. Mason Keene moved too fast, pushed too hard, and seemed unusually confident for a man evicting a tenant who had lived in the same unit for more than 20 years. That kind of confidence usually meant one of two things. Either he was right, or he thought nobody had the paper to prove he was wrong. The problem was proof. Earl remembered the letter. So did his late wife. But after the lockout, half their records were missing. Boxes had been split open. Folders were water damaged. One copy of an old lease had mold on it. Another was missing pages. Mason's lawyers said there was no enforceable side agreement in any property file and no surviving obligation outside the current lease terms. Mason even signed an affidavit saying he had personally reviewed the legacy records and found nothing granting Earl special rights. That statement lasted 12 days. Because Tessa Dixon, searching through a battered cedar chest Earl had kept in storage at his VFW hall, found a manila envelope tucked inside Clara's old church Bible. Inside was the original letter, crisp signature, notary stamp, company letterhead, one page, a lifetime promise. And when Maya Alvarez looked closer, she saw the line that changed the entire case, binding upon heirs, assigns, purchasers, and agents. The courtroom didn't react all at once. It tightened. Judge Varga read the letter twice. Mason's lawyer asked to inspect it. Maya entered a notarization log, old rent receipts showing the exact fixed amount had been accepted for nearly 2 decades, and maintenance records with Earl's initials from the year Arthur had been ill. Suddenly the agreement wasn't sentimental. It was contractual, consideration, performance, reliance, continuity. But the real damage came when discovery widened. Because once the court saw that one letter, Maya Alvarez got access to the internal acquisition folder Mason had sworn contained nothing relevant. And there it was, a scanned copy of the same letter in a due diligence packet from August 2022, flagged with a yellow tab. Someone had written in the margin, "Legacy occupancy claim, resolve before vacancy certification." Next to it were Mason Keene's initials. Then came the email. "Buyout not worth it," Mason wrote to his operations director 3 weeks before filing against Earl. "He's old, isolated, and doesn't have counsel. Push default, then clear 3R before lender inspection." That was the moment the air changed, because now this wasn't a disagreement over a tenant's memory. It was evidence of intent. If you believe no one is above accountability, stay with me. This is where the story stopped being sad and started becoming fatal for the man who caused it. Maya didn't stop with Earl's file. She subpoenaed financing documents tied to Mason's pending redevelopment deal with Harbor Crest Capital, a $14.6 million refinancing package contingent on the building being delivered free of legacy tenancy restrictions, undisclosed occupancy rights, or litigation likely to affect possession. Mason had signed that certification too. Under oath, he tried one last maneuver. He said he never actually read the flagged attachment. He said staff handled historical records. He said the email was frustration, not policy. Judge Varga let him finish. Then she asked why 6 other elderly tenants in 2 neighboring Keene buildings had received nearly identical renovation notices with permit numbers that did not exist. Silence. Then she asked why Earl's fixed rent amount, $525, had remained coded in the company ledger under a legacy designation labeled LT3 for nearly 20 years if no special tenancy existed. More silence. Then she asked the question that broke him. So when you told this court there was no document, no special obligation, and no knowledge on your part, that was false, wasn't it? Mason looked at his lawyer. The lawyer looked down. And just like that, the man who had treated removal like administration found himself staring at possible perjury, lender fraud, punitive damages, and a housing court record that was now drawing reporters. The ruling came in stages, each one worse than the last. First, immediate restoration of possession and emergency sanctions for the illegal lockout. Then compensatory damages for destroyed property, medical disruption, emotional distress, and wrongful eviction. Then attorney's fees. Then punitive damages, because Judge Varga found the conduct wasn't merely unlawful. It was calculated, deliberate, deceptive. The total judgment against Mason Keene and Keene Sterling Properties came to $8.9 million. That number alone would have hurt. What bankrupted him was everything attached to it. Harbor Crest froze the refinance. 2 covenant defaults triggered across separate commercial loans. An insurance carrier reserved rights and declined coverage for intentional misconduct. The City Housing Department opened a pattern and practice review into Keene's eviction filings. 3 more tenant suits were filed within a month. A partner walked. A development buyer withdrew. 11 days after the ruling, Keene Sterling filed for Chapter 11 protection, listing the judgment, frozen credit lines, and pending litigation as immediate causes. Earl Dixon went back to apartment 3R, but only long enough to collect what was left of his life and do one thing he had asked for from the beginning: put Clara's nameplate back on the mailbox, not because he planned to stay forever, because he wanted the record corrected. That mattered to him more than the money. He had spent months being described as late, difficult, non-compliant. In court, he got something rarer than compensation. He got the truth entered into the record with the full force of law behind it. And that is why this case still hits so hard. Not because a greedy landlord lost money. Men like Mason Keene lose money every day and call it strategy. What destroyed him was the thing arrogant people never planned for: a patient opponent, a clean paper trail, a judge who could tell the difference between confusion and calculated deceit, and one old letter that refused to die just because the man who wrote it was gone. In the end, Mason Keene had towers on his pitch deck, lenders in his phone, and lawyers billing by the hour. Earl Dixon had a cane, a dead wife's Bible, and a promise on fading letterhead. Only one of those things survived court. If cases like this make you think, let me know in the comments, because the most dangerous people in stories like this are never the loudest. They are the ones who think nobody kept the page that proves what they did. Mason tried to turn a veteran into paperwork. Instead, paperwork turned him into a warning. And that may be the cleanest kind of justice there is.